we keep going crazy.
Abdul Kul Bazoon Capital Attack Padana Bet Mafu Hadis Aishi Fikulu Anuki Fian Aishi Fikalu Kula Shikalu Na Atakun Fikalu Anuki Feragun Shikalu Wakalu Feragushi Anuki Wahid Bakalu Wakalu Wahid Man Nuk Aikilu Angie Kama Feragun Shikalu Wakama Farid Aikilu Aqueno Kubiku Kama Kama Kafazu Kalu and Anuki Kaba Hawa Kalu Kaluna Kalu Yakun Keki Kalu Babu Kevin. Again, all pairs these find of it all. I am in the double all of here, all in all. I am a part of all and all is a part of me. I am one with all and all is one with me. I can succeed as a part of all and fail as an individual. I can be all I wish in all as long as my wish is to stay in all. I am never alone. All is I am. All can I can. All does I can.
Jacob York was part. He was the main principal person that was connected to the FBI, connected to Sheriff Seals, who brought witnesses to the government, and he wanted Damian Pryor to take the stand to tell the jury, who was not in the courtroom, what Jacob York had told him on or about November of 2001. Damian Pryor said that Jacob told him that he is going to take Dr. York down. We're going to take him down. He told him about his role as far as being the facilitator of the FBI. He was on the payroll, and he wanted Damian to be a part of it because he was trying to meet Damian or Duswa in order to get Duswa to forge some documents. And Duswa on the stand was also talking about the orgies that Jacob had and the people who he was trying to recruit. And the judge had stopped Duswa. At first, the judge told Duswa and told Attorney Patrick that he was going to let in Duswa's statement that what Jacob told him as far as Dr. York going down, but he was not going to let the other statements that Duswa was making to come into the jury. All right, because the reason why the judge said that was the judge felt that was before the fact. As far as those statements that he was making. So the judge, in essence, was disconnecting the conspiracy aspect from Adrian Patrick's defense.
But that wouldn't have been a strong argument anyway. The court would have known that, right? Because they could have just came up and say that's hearsay with Jacob, right?
Well, yeah, but Adrian was approaching it as a hearsay exception. There are exceptions to the hearsay.
Okay.
Okay, and Adrian was approaching it from that angle, all right? And when the judge did not allow, because you had two witnesses. You had Dr. York's daughter, Leah York, and you had Damian Pryor. Now, here's the question. If they had to be introduced as witnesses around the midnight hour, then why wasn't they on the witness list during Ed Garland's tenure as Dr. York's attorney? Because Adrian only been on the case since December 12th, 2003. Ed Garland been on the case since the case started.
Who actually asked them to be witness in the wee hours? Because that's something that makes you go, where the hell did they come from, and what was their intentions for real? That's the way I think it. I'm not saying that's what you're saying, but that's raising an antenna to me.
Well, basically, okay, That's not a question that an attorney should have to answer. That's a question that Duswa and Leah have to answer. Obviously, if Jacob York had approached you on around November 2001, and Dr. York got arrested in May of 2002,
right?
The question is, who did you tell? Period, about what Jacob was doing.
Five people, exactly. Who did you tell? Period. Things that make you go,
Yeah, well, of course. That's the reality of it. I wouldn't. It wouldn't be a question that I would ask Attorney Patrick. It would be a question of whoever, whether Duswa or Leah, at what point did they volunteer the information that they're trying to get before the jury now in 2003? If you had the information in 2001, the question is, did you relay that information to Dr. York? I'm not being accusatory. All I'm saying is that preparation is weight in gold. Okay? Right. When you prepared, that means that you have a latitude to do, to maneuver, to do certain things, to be, to do what you need to do in order to get out of harm's way. Which obviously Dr. York was in harm's way at this point. So that's a question that they would have to answer as to, why it took y'all so long.
Absolutely.
And maybe they did go to Ed Garland, and maybe Ed Garland, felt whatnot that, they should not be called in as witnesses. You never know, because a lot of these documents are sealed. So you have to get, unseal most of these documents to really find the root of the problem, which is enormous. This, when you're talking about 65 sealed documents of court orders, and you got the government, hiding sealing most of its documents. They put in over 47 documents. Dr. York attorneys throughout his case had put in around 42, 43 documents into the court. Then you have to look at this case within the time span, because Ed Garland was on the case over 20 months before Adrian Patrick got involved in the case. So you're talking about a lot of paperwork. You're talking about a lot of going back and forth. Yes, there were suppression motions, which they call a motion in limine or a limine. That was done, but the point of the matter is to what extent it was done. Was it sufficient or was it insufficient?
Right.
Because what came to that jury at trial, you got to look at, so you can look at how well an attorney is doing at trial based on how well he did at pretrial. Pretrial, you got the pretrial motions, you got the bill of particulars, you got challenging the indictment, you got discovery, you got your witnesses, you got the introduction of what evidence that you tend to bring to the trial in discovery. You have all that stuff. And the only way that you can really get a clear understanding or overstanding based on what you have, those documents have to be released. They have to be released. You have to see the trail of how this case was flowing. So when you look at the case from a trial point of view, the government put on three theories in this case. 3 theories. One, they portrayed the organization or the community under Dr. York as a cult with a religious content or religious context, or both. 2, the other theory was Dr. York was a mafia don who had a corrupt organization. Those two went to the jury. Those two theories went into the jury room. 3, Dr. York was a child molestator, and the federal government, through the Mann Act, was actually prosecuting a state crime. So any attorney that came on this case in the midnight hour, as Adrian had every right to ask the court for more time, and Adrian did ask the court for more time. The problem was that the judge had shown his bias and prejudice towards Dr. York, and he pretty much forced Adrian to accept an attorney or attorney law firm that Dr. York had fired. Unwanted counsel. Nobody, the Constitution do not allow any judge to force a counsel that you have paid for out your own pocket that you considered unwanted, that you didn't want. But that's what happened in Dr. York's case. Let me finish reading this rest of this motion. See that the court denied the defense the right to cross-examine alleged victim witness Crystal Harding on credibility issues, such as her frequent lying and theft. The door to those issues was already open through the testimony of other witnesses. Thus, the defense should have been allowed to fully cross-examine this witness on those issues so that the jury would be able to properly evaluate the witness credibility. Credibility of a witness is always a relevant issue, and the defendant has a right to a, quote, full and sifting, end quote, cross-examination. Here is clear that Adrian was being stifled by this judge. They would not allow him to vigorously go after Crystal Harding in terms of opening up and showing the jury that she had credibility issues.
It's interesting.
D, the court, you have a question about it?
No, you're going to.
The court denied the defendant a right to present a proper defense by denying to allow hearsay evidence under Federal Rule of Evidence, Rule 803. Federal Rule of Evidence is an exception to the hearsay rule. That means that is a area where if they say that you cannot allow a certain thing to happen in the court process, then it's your job as an attorney to find an exception to that rule so that you can use that exception to come into the back door where they are denying you to come through the front door. You want to be able to come back in, and there's and with most law or statutes that either in the federal jurisdiction or the state jurisdiction, you're going to have an exceptions to the rule. And Adrian was trying to use that exception. This is the second time that he tried to exercise an exception to the hearsay rule in this case. The court denied the defendant a right to present proper defense by denying to allow hearsay evidence on the Federal Rules, Rule 803. This evidence was related to an incident where Khalid Ennington was raped by his older brother between the ages of 6 and 9 years old, approximately. The significance of this information is that Khalid Ennington stated that the sexual abuse by the defendant started definitely when he was 13 years old. However, in his medical report, he stated that the abuse started when he was 6 years old. This is significant because the defense theory of Khalid Ennington was that he related a real-life experience to the jury, but he substituted the defendant as the perpetrator instead of his brother, who was the true perpetrator. This theory is called, quote, perpetrator substitution, end quote. The defense wished to introduce hearsay statements made by Khalid Ennington's father, made immediately after he found out about the rape. After being questioned by defense counsel, Khalid Ennington denied that the incident ever occurred. Thus, these hearsay statements would have been relevant, probative, and extremely valuable to the defense in providing an adequate defense. E, that the court erred in denying the defendant's request for a continuance. The defendant's counsel informed the court in no uncertain terms that the defendant's defense will be inadequate without a continuance, that the defense needed more time to prepare because of the relatively short amount of time between the time of the superseding indictment and the trial, and the short amount of time that attorney Adrian Patrick was lead counsel. It was clear from the record to this case that there were substantial problems between the defendant and his previous counsel. Thus, termination of counsel was not too unnecessary act of delay, but a necessary act, of protection by the defendant in an attempt to protect his right to a fair and zealous counsel. 4, that the verdict is contrary to law. 5, that the verdict is contrary to the evidence. 6, that the verdict is strongly against the weight of the evidence. 7, that the court erred in allowing the trial to go forward on a superseding indictment that was returned by a tainted grand jury that was selected from the Macon Division of the Middle District of Georgia. The relevant facts are as follows: that on October 28, 2003, this court issued an order on defendant's motion to change venue. This order stated essentially the following. This is the judge talking now. The court grants defendant a motion as to Federal Rules Criminal Procedure P21 because the court is satisfied that without changing venue for the trial of this case, the defendant cannot obtain a fair and impartial trial in the Macon Division of the Middle District of Georgia. The court goes on to state the following, quote, in reaching the conclusion about where to try this case, the court has carefully considered the problem of media saturation and potential bias involving not only the allegations against Malachi York, but also reports about the Nawabians because York is the leader of the Nawabians. The court regularly reviews and has reviewed both the Macon Telegraph and the Atlanta Constitution for many years. All right, now let me stop this right here. I'm going to interject something here. The court just gave you a false assertion when it said that the court regularly reviews and has reviewed both the Macon Telegraph and the Atlanta Constitution for many years. Now, the judge was only a judge after 2001. So he could not, as he indicated, the court had reviewed, all right, the Macon and Atlanta Constitution for many years as by the court, because he was not a judge. He was a recent addition to the judiciary. So that's a fallacy right there. He may have viewed the Atlanta and media depiction of the Nawabians and Dr. York as an attorney for many years, but not as a judge. He go on to say, the court, over the years, the court has noticed in both newspapers coverage of defendants' criminal case and articles that reflect unfavorably on the Nawabians that could adversely impact the defendant at trial. Again, the same premise.
So this man was following, he was following the case before he even became a judge.
Well, yeah, but he is saying that the court had reviewed the Atlanta and Macon media circuit for many years as it applies to Dr. York and the Nawabians, and that's incorrect.
Okay. Right.
Over the years, the court has noticed in both newspapers, again, over the years, the court has noticed in both newspapers coverage of defendant's criminal case. That's a fallacy. And argues that reflect unfavorably on the Nawabians that could adversely impact the defendant at trial. But the only criminal case that he's talking about is the criminal case that he was sitting on. The court has grave concerns about trying to select a jury in this case in any division in the Macon and Atlanta media markets, end quote. Adrian go on to say, with the above reference rationale as the foundation, that there is a, quote, grave concern, end quote, about selecting a jury in light of the negative media publicity would logically show that any jury, trial, or grand jury selected in this district would be tainted and equally affected by the same negative publicity. Thus, the court has effectively and constructively taken judicial notice of the fact that any jury selected from this district would be tainted or have an extremely high probability of being tainted. Thus, it is clear that the grand jury for this superseding indictment was erroneously selected from the same district that the court, per its own order, issued October 28, 2003, has already ruled insufficient. Thus, the court should have dismissed this superseding indictment and should have not allowed the trial to go forward. What Adrian is saying here, that the court, after declaring the Macon and Atlanta jury pool tainted, the grand jury tainted, it goes back and allows the government to come back with a superseding indictment from the same grand jury that the court had declared a tainted grand jury.
Which gives a perfect reason for a retrial or, a new trial, something at least.
It should have.
Right.
But more importantly, okay, this is what people don't know. The superseding indictment was released by the government on around November 21st, 2003. That superseding indictment was not challenged by Ed Garland. It was challenged by Adrian Patrick when he first got on the case on December 12, 2003. Adrian Patrick challenged the superseding indictment, not Ed Garland. To me, that's very strange.
Yep, that is strange. How long did it take for Adrian to put that together, for him to notice all of that? He didn't even have that much time to actually pick up on a lot of errors and, you know, misconduct with the court to put this together. How long did it take for him if he just got on the case around that time?
Well, when Adrian came on the case, all right, he put in several motions of limine, and he put those motions in to suppress certain things that Ed Garland did not suppress. Ed Garland did suppress motions earlier, but motions in terms of, for example, he wanted to suppress the fact that the government was calling the organization a cult. He wanted to suppress and put motions in to suppress Dr.York had many wives. All this stuff that he tried to suppress in order to clear out the bias and prejudice that was brought into this case by the government, which it hoped to deliver to the trial jurors. That's what he did. And then he challenged the superseding indictment with his own indictment, and Judge Rawl dismissed his motion challenging the superseding indictment.
That's crazy. So he only had like a couple of weeks to put that together, right?
Yeah, a couple of weeks to put it together, and it got so strenuous between the fact that Garland had to face the office hiring new attorneys, because you had Frank Rubino, and then after him you had Adrian Patrick, and it got to a point. If you look at the transcript of the December 16, 2003 transcript, the judge had to ask Ed Garland, who are you still the lead attorney? And Ed Garland said, well, that's going to be determined a little later. And the judge said, okay, when you find out, all right, just let me know who is going to be the lead attorney. At that point, it is reasonable to conclude that Ed Garland was throwing up his hands, even though Ed Garland had provided quite a few instances of ineffective assistance of counsel, but because he had to contend with the members of Dr. York's tribe coming in with their own legal documents and putting in stuff, and then later on find out that they wasn't even paying for the stuff, the motions and stuff. They wasn't prosecuting the case. The court did not allow that stuff for failure to prosecute that pro se was coming in Dr. York's name and was not, properly litigated. So Ed Garland had to deal with a lot of stuff that an attorney should not have to deal with.
Okay.
But it still doesn't negate the fact that he caused a lot of problems for Dr. York in this case. Jurisdiction is the head issue on the list.
Yep. That's true. All right.
Mm-hmm.
No, you go ahead. You got it, Flo.
Okay. Now here's where it gets real funky. Number 8, that the court should have dismissed the entire jury panel because several jurors indicated that conversations took place amongst them that the defendant pled guilty before. End of case right there. When you withdraw your plea, which Dr. York did around October, it carries with that withdrawal, it carries the restoration of your presumption of innocence. No jury is supposed to be in that jury room under the pretense that they know that you have pled earlier. You're dealing with, at that point, you're dealing with a tainted jury panel. At voir dire, okay, that is, a process where you're going to pick your jury pool from.
Right.
You're going to find out, you're going to ask certain questions about the juror, knowledge about the case, what they read in the paper, what they seen on the internet. Well, let me say this, brother, okay? Dr. York had a way out, and his only way out was to reverse and go back to the plea that he made, okay? That was his only way out at this point. I don't know whether him and Attorney Patrick had a discussion. It would be interesting to know that if there ever came a time when Attorney Patrick had told Dr. York, look, they got a 13-count superseding indictment against you. They got the RICO charges against you. They got made-up structuring charges against you. They got the Mann Act against you, and the federal government don't even have jurisdiction to even bring in the Mann Act. They have jurisdiction. As Garland had articulated at Dr. York's detention hearing, and he said, there are over 5,000 to 4,000 child molestation cases in the state of Georgia, and I venture to say, with no federal intervention. Ed Garland was saying that my client is being singled out. And that's when he made the jurisdictional, he raised the jurisdictional issue. The problem with that was that subsequently, Ed Garland had never put in a motion, which is contrary, because the jurisdiction issue should have been settled. Ed, right there, Ed Garland should have said, Your Honor, we don't need to deal with this detention hearing for a bond because the jurisdiction here is a lack of jurisdiction here. I'm raising it for you to show my client how the federal government has jurisdiction over him. The judge told him at that day, Judge Claude Hicks told him, you can argue jurisdiction later by motion, but today we're going to deal with detention hearing for a bond. The magistrate judge was in plain error at that point. Jurisdiction cannot be waived, nor can it be forfeited.
All right, going to make you breathe a little bit. Do anybody have any questions they want to throw up here? Raise your hands, or first one, come in, mute your mic to ask the question before we continue. Anybody? All right.
Oh, it's me. It's Rochelle.
Hey,
I just want to thank. I'm good. I just want to thank the gentleman for coming in and clarifying a lot of things. Any questions or concerns that we had about the case. I know some people were probably skeptical of, well, what about this? Well, what about that? And you came in and you broke it down and you gave us a lot of clarity. So I do want to thank you for that.
Well, thank you, sister.
And I do have one question.
Mm-hmm.
Moving forward, since those people are actually 21 and over now, that lied about the molestation charges, are we able to say, hey, you're an adult now, what happened to you? You don't have your parents or whoever coerced you in this. Are we allowed to actually sue them for what is called or defamation of character? Are we allowed to do something in that sense? For
well, until they come under the preview of newly discovered evidence. All right, that's the only thing that would clear the air in reference to what Dr. York remedy will be in this situation. And new evidence is guided by a criteria that you would have to make before the court. One, you got to show that the evidence could not have been detected by your attorney during trial, even under due diligence. 2, it cannot be evidence that is how do you say it? Cumulative. It cannot be cumulative, nor can it be. All right. And 3, it must be the newly discovered evidence must be weighed by the court compared to the other evidence that they have used in the case to convict Dr. York. So there's a standard that or test that has to be applied to anyone who's coming into the court and telling the court to give them relief based on newly discovered evidence. As with Abigail, she should not have been looked at as newly discovered evidence. 1, because I was going over that transcript of the trial, of the new trial hearing, and Jonathan Marks had admitted that Abigail came to him saying the affidavit was false after he had submitted the motion. And I looked at the date that he submitted that motion, and he submitted that motion to the court, his new trial motion, based on newly discovered evidence around May 4th, 2004, 4 months before the August 13, 2004 new trial hearing. So he had ample time to, before he even walked through the door, he had ample time to supplement Adrian Patrick's new trial motion and added this newly discovered evidence if he had, which he didn't have, but come through and supplement Adrian Patrick's new trial motion and brought it before the court on August 13, 2004. But what he did was he withdrew Adrian Patrick's new trial motion, which had the errors that I'm reading to you now, that I'm reading before you now, and he went forward with a motion that he knew was weak before he even walked into the courtroom that morning.
Somebody was in his ear.
Huh?
Somebody was in his ear. Somebody.
Oh, no. I'm quite sure. I'm quite sure. And you know, the tragedy, this is what I believe. This is what I believe based on, and I know it's hearsay, but even through hearsay, you can draw a plausible conclusion. Thank you, brother. Plausible conclusion. And it would be that, wait a minute. Dr. York attorney, Jonathan Marks, was put into a bind. I believe that he had no way out. And the reason why I believe that, because during that time, in August 2004, I had gotten from a reliable source within the office or the perimeter of the office that Dr. York had told Rochelle 2 weeks before the August 13, 2004 hearing to fire Jonathan Marks. Now, I don't know whether Dr. York was feeling something spiritually at this point, but it definitely came to fruition at that August 13, 2004 hearing. Also, I want to also establish that Jonathan Marks was not a new attorney on this case. He was an attorney who worked for Dr. York many years ago. As far as taxes, he was the same attorney who had written to the court when they were sentencing Dr. York back in the 80s. He wrote a letter to the court asking the court to give show leniency to Dr. York. So attorney Jonathan Marks and Dr. York had a long-standing good relationship. What I believe happened here, based on what I was told, that Jonathan Marks was in the court, in the clerk's office, and he overheard the clerk calling a bunch of Nawabians who was out there protesting a bunch of niggas. And he went and he told the office what he heard. And the office put it on a flyer and put it out there. And the clerk concluded that the only person that could have told them that was an officer of the court. At that point, I believe that Jonathan Marks had to do the devil's bidding. He had to do what Judge Raw and the rest of them. And I'm gonna tell you something. We're gonna go over myself and Sister Nunette. We're gonna go over that August 13, 2004 hearing.
Okay.
And we're gonna lay it out for you so that you will be able to connect not only Adrian Patrick's new trial motion, but also his judgment of acquittal.
Okay.
That
Forward to that.
Jonathan, I'm sorry.
I'm looking forward to it.
Yeah, that Jonathan Marks he withdrawn Adrian Patrick's new trial motion, but he did not withdraw his judgment of acquittal. To this very day, that judgment of acquittal has never been adjudicated by Judge Raw.
All right.
All right. So let me finish this. 9, that the verdict is based upon matters, facts, documents, and evidence that were obtained as the consequence of an illegal search and seizure. Said matters, facts, documents, and things were all illegally and improperly presented to the jury, incident to and in connection with the presentation of evidence to them that gave rise to the return of the guilty verdicts and forfeiture.
Adrian was going in.
Oh yeah, he was going in on. That's why they had to get rid of his stuff.
Right.
See, they was looking at Abigail when she had already, according to Jonathan Marks, she had already said, "Hey, I lied on my affidavits."
Mm-hmm.
So they constructed that hearing for the purpose, not for Dr.York recantment, but for them getting rid of Adrian Patrick's motion for new trial and his judgment for an acquittal, and put in place of that Jonathan Marks' no can do motion based on discovery of newly discovered evidence. And Abigail was supposed to have been the newly discovered evidence, and under the rules of the newly discovered evidence, she could not have been newly discovered evidence, because a lot of what she was saying was accumulative. It was impeaching, and it could not have benefited Dr. York. So by essence, they were allowed to kill 2 birds with 1 stone. Abigail's recantment and Adrian Patrick's motions. The last one he states here, 10, that the court allowed the government to exceed the scope of rebuttal after the government had rested in its case in chief by allowing the government to reopen their case and present new evidence in rebuttal. The court allowed the government to present an entirely new alleged victim, Miss Franklin. Additionally, after the court overruled the defense objection to the presentation of this testimony, the court stated that the only thing that the witness can say is, quote, that she was molested, end quote, and that she was absolutely not allowed to go into details over and beyond that statement. the government never instructed their witness as to the court-ordered limits of her testimony, but instead, the government allowed the witness to go into details in direct contradiction to the court's order. Additionally, the government sought information about more than one act of child molestation. The defense asked for a mistrial. The court denied the defense motion. 11, that the transcript, he would even preserve his right, that the transcript in this case will not be prepared for at least 60 to 90 days. Thus, the defense requests time to modify and amend this motion when the transcripts are complete. For the above referenced reasons, the defense requests that this court grant a new trial in this case.
Let me tell you something. Not only will they persecute you, they'll lie on you. They'll fabricate lies. They'll imprison you and create cases around you. The same way they tried to defame the Honorable Elijah Muhammad, and then they tried to defame Malcolm X, and then they even tried to defame Dr. Martin Luther King by some secretary. That's what they'll do. They'll imprison you, and then they'll create lies to turn your own people against you. They'll persecute you after righteous namesake. The same way I'm talking to you, they're going to come after me eventually. Believe it. They're going to say, that man is too dangerous. I don't like him. Let's make some lies up on him. Let's turn his people against him. Let's imprison him. And if we can, let's kill him because his people won't help him anyway. And they'll try it. And I'll be at the mercy of the devil. You understand?
Abdul Kul Bazoon Chapel Attack Padana but Mafu Hadi Station Pinnacle. Anuki fi and Aisha Shikalu Wakula Shikalu. Na at the Kun Fikalu. Anuki Ferragun Shikalu Wakalu Ferragushi. Anuki Wahid Bakalu Wakalu Wahid Man. Look Aikilu Angie Kama Ferragun Shikalu Wakama Faid. Aikilu Aqueno Kudik of Fini Fikalu. Kama Tawakamaka Fadu Kalu Amy Fikalu. Anuki Kabahawa. Kalu Kaluna. Kalu Yakum Keshi. Kalu Babu together. Again, all pairs, I am in the double all levels. We are all in all. I am a part of all, and all is a part of me. I am one with all, and all is one with me. I can succeed as a part of all and fail as an individual. I can be all I wish in all, as long as my wish is to stay in all. I am never alone. All is I am. All can I can. All does I can.